Good morning, good afternoon, or good evening, wherever you may be. I'm going to take you through local content compliance requirements for companies planning to do business in oil and gas sector in Uganda. Following the discovery of oil and gas, it came with the general excitements. The expectations were high. A lot is expected out of this sector. At the end of it all, the question has arisen: how will the locals benefit from this oil and gas project? Hence the concept of national content. So the government has determined that national content strategy in form of policy and regulatory measures.
Daniel, apologies for interrupting. I think your camera is still off.
Oh.
Apologies for the interruption. Now we can see you.
Oh, thank you. Yes, the government has determined that for the locals to benefit from this oil and gas, there's need to have in place national content strategy in the form of policy and regulatory measures that focus on increasing the use of locally available labor, technology, and other resources in the oil and gas sector. So these measures are meant to be complied with by all companies licensed or subcontracted to engage in the exploration, development, and production of oil and gas in the country. The question is, what is national content? How do we understand national content? The applicable laws, the Petroleum Exploration, Development, and the Production National Content Regulations, provides a definition of what national content is. Basically, it means the level of use of Ugandan local expertise, goods and services, Ugandan companies, Ugandan citizens, registered entities, and business in the oil and gas sector. Another definition can be borrowed from the 2018 National Content Policy for the petroleum sector in Uganda, which defined this as the value added or created in the Ugandan economy through the employment of Ugandan workers and the use of goods produced or available in Uganda and services provided by Ugandan citizens and enterprises. By way of comparison, the Nigerian oil and gas industry content of 2010 defined it as the quantum of composite value added to or created in the Nigerian economy by a systematic development of capacity and capabilities through deliberate utilization of Nigerian human material resources in the Nigerian oil and gas sector. From both definitions, we're able to ascertain that emphasis is on the use of local expertise, service providers, and local resources in the oil and gas sector. In summary, the extent of use of the local expertise, service providers in the oil and gas sector. So by way of comparison, the same position in Nigeria applies to Uganda in summary. What then is the justification for the local content? Why do we have this in place? Under the 1995 Constitution of Uganda, all natural resources are held by government in trust on trust or on behalf of the people of Uganda. So there's need to ensure that the utilization of the resources, which is held by government on trust, results into benefit to the locals. So the government has a duty to hold its natural resources on behalf of the citizens. Its utilization should involve the citizens as well. And to contextualize it further, there's need for the social license. If any project of this magnitude is to be carried on, the host communities must participate. So with the concept of local content and incorporating of the citizens or the local communities in the sector in a way the licensee or the contractor, subcontractor will be getting a social license from the locals. Without the social license, they may vandalize the intended activities and in the end, frustrate it. The compliance requirements are categorized into 4. One of them is registration of the National Supplier Database. Under the Petroleum Exploration, Development, and Production National Content Regulations, the Petroleum Authority shall develop a national supplier database for petroleum activities. A company shall not provide goods, works, or services for petroleum activities unless it is in the national supplier database. That is the starting point. Having been registered or incorporated in Uganda or any other part of the world, before you can get into the activities associated with oil and gas, you must be registered with the National Supplier Database. The Petroleum Authority of Uganda, the regulatory body for the sector, developed a National Supplier Database, a register of all entities and persons with interest to provide goods, works, and services, the oil and gas sector in Uganda. This registration is done online, and one of the requirements is the evidence of legal status, certificate of incorporation, or certificate of registration. Information on the shareholding and management of the company. You will need a reference letter from the bank or proof of liquidity status, proof of compliance with the tax laws. In the case of Uganda, you'll need tax clearance certificate from Uganda Revenue Authority. Proof of social security compliance. You'll need clearance from National Social Security Fund if you're an entity registered in Uganda. A national content strategy or plan showing Ugandans employed or to be employed by the entity, the goods and services to be used by the company, and whether those goods and services are from Uganda, the extent to which the Ugandans are going to be involved in the provision of the goods and services to the company. That is phase 1. Now that you have been registered in the National Supply Database, we assume you have been licensed or you have got a contract from a subcontractor or a licensee in the oil and gas sector. The other requirements, compliance requirements, has to do with the provision of goods and services by Ugandan companies as one of the requirements. The licensee, it is contractors and subcontractors shall give preference to goods which are produced or available in Uganda and services which are rendered by Ugandan companies. So where those goods are not available in Uganda, they shall be provided by a company which has entered into a joint venture with the Ugandan company. As long as the Ugandan company has 48% and above shareholding in the joint venture. The licensee, it is contractors and subcontractors shall also ensure that the Ugandan entities are notified of the upcoming contracts in the sector as early as practicable. In both regulations, preference is given to Ugandan companies in the provision of goods and services. There's the therefore to understand what constitutes a Ugandan company. If you are a foreign investor coming to invest in the oil and gas sector, and the goods and services for which you seek to be provided in the sector cannot be provided by a Ugandan company, cannot be provided by a Ugandan company 100%, you are required to ensure that the Ugandan company has a joint venture with a foreign company, and the Ugandan company holding 48% of the shares. The question then is, what amounts to a Ugandan company? Can you engage any company that is registered in Uganda and say, this is a Ugandan company, let us have a joint venture? No. Under the relevant regulations, the Ugandan company must be the one that provides value addition to Uganda, uses available local raw materials, employs at least 70% Ugandans. In addition to that, it is a joint venture with a foreign company has been approved by Petroleum Authority of Uganda. It is not enough to say you have entered into a joint venture with the Ugandan company. No, the joint venture arrangement must be approved by the regulator, Petroleum Authority of Uganda. So in reaching out a joint venture arrangement, there are certain things that the Petroleum Authority will be looking at. The venture must demonstrate technical and financial competence and be able to deliver the goods and services in a timely manner. Capacity to transfer knowledge and technology to Ugandan citizens. Demonstrate experience in the provision of the required goods and services. A company must fulfill all the above conditions. It is not enough to meet one of the conditions in order to qualify as a joint venture. The third aspect is the requirement of companies to employ and train Ugandans. The license shall, within 12 months after the grant of a license and on each subsequent anniversary of that grant, submit to the Petroleum Authority for approval a detailed program for recruitment and training of Ugandans. The program must provide for the training and recruitment of Ugandans in all phases of petroleum activities and shall take into account gender, equity, persons with disabilities, and host communities. These are the host communities in this context are the inhabitants of the district in which the petroleum activities is going to take place. As I indicated earlier on, investment of this magnitude requires social license. The host communities or the locals must support you for your project to succeed. The license is also required to develop and submit to the authority for approval a transparent policy and plan on training and employment of Ugandans, specifying the required minimum qualifications. A detailed plan for recruitment and training of Ugandan citizens in the activities shall include an outline of the hiring and training needs of the licensee's major contractors with a breakdown of the skills required, the activity-specific training requirements, and the anticipated expenditure to be made directly by the licensee in implementing the employment and training plan. A time frame for employment opportunities for Ugandan citizens for each phase of the petroleum activity, and any other information that the authority may require. And on the ground, that's exactly what's happening. All other investors who are already involved in the sector are complying with it. It may appear complex and lengthy, but Petroleum Authority has developed what we call guidelines that the licensees or contractors are supposed to follow. In the event that you are not able to get Ugandans to employ and you are bringing expatriates, there's need for prior approval by the Petroleum Authority. The law provides that every licensee or contractor shall apply for a recommendation from the Petroleum Authority prior to making any application for work permits for the expatriates, the government, ministry, department, or agency responsible for immigration. Such application shall be accompanied with certified or notarized academic documents, curriculum vitae by recommendation certifying experience and job history referenced, a description of responsibilities, duration of the proposed employment in Uganda, evidence that Ugandan nationals are not qualified for the job, list of Ugandans identified for training, individual training plan for the replacement of the expatriates. The Petroleum Authority, being the authority with the mandate to regulate the sector, has a discretion to give the recommendation. It is not obvious that after making the application to be granted on several occasions, you can, in a year where you have 200 applications, you find that only 80 has been approved with a reason or deferred. The other aspect is the training, technology transfer, and capacity building for citizens. Under the Petroleum Exploration, Development, and Production Act 2013, Section 127, to be particular, a license shall include a clearly defined training program for the Ugandan employees, which may be carried outside or within Uganda, and may include scholarships and other financial support for the education. And this extends to training of government officials. Some of the players already in the sector have trained several Ugandans in this sector in areas of exploration, administration, technical aspects has already been carried out by the players. So any other player coming in is expected to comply. For the case of government officials have been trained in the Ministry of Energy, Police, Auditor General's Office. So every investor seeking to invest in the sector must bear this in mind. So the license must also include a commitment by the licensee to maximize knowledge transfer to Ugandans and to establish in Uganda management and technical capabilities and any necessary facilities for technical work, including interpretation of data. So what some of the players have done is to reach an understanding with the training institutions in Uganda that initially were training Ugandans in the other sector, but with coming to play oil and gas sector, they decided to improve on the capacity, introduce on relevant courses in the sector. And many Ugandans have benefited from this. Finally, local content requirements are in form of measures that increase that focusing, that are focused at increasing use of the locally available labor, technology, and other resources in the oil and gas sector. The focus on transfer of technology by companies engaged in the extractive resource sector to citizens with the hope of assuring them income, employment, and ultimately sustainable development. Participation of citizens in the oil and gas sector will require capacity building and training of citizens to work in the sector. Such training needs to focus on building capacity for direct employment and for services in the sector. So every company intending to engage in the oil and gas sector needs to equip itself with above requirements so as to ensure compliance. Thank you for listening. I will be on standby to answer any questions you may have in that context.